Hi guys, so just waiting for Govind to come back, and then we'll start off with the Q&A session because there appear to be a lot of questions here. Great, Govind is here.
So everyone, we're back here with Sudipto,
Yeah.
and going to
Govind,
take.
I hope the previous session has come. I mean, I did follow your steps, but
Yeah, don't worry, don't worry. I use.
yeah,
You see, it's good, good. So of course, definitely, you were saying something. Let's finish that.
yeah. So when you entered the market late, you have essentially thrown money. Why? Because you had an easier regime as compared to the others, but more importantly, you've thrown money to collect customers from others.
Yeah.
The reason the others face a problem is because they had to make significant investments to create the infrastructure for 2G and 3G. And because there was no pan India license, so costs rose. This led to a situation where they took on a lot of debt. That debt has now created problems for them because of the fact that they have to eventually pay that money back. And this
Mm.
has now been compounded by the AGR issue. I mean, they were already in trouble irrespective of AGR. But
Mm.
the AGR has obviously compounded it because, and I personally blame the government for this because they should have clarified or come out with a clarity within the policy rather than to keep litigating this issue right up. Because you have to recall the telecom companies won before the TD sat. They
Correct.
lost before the Supreme Court, but they won before the TD sat. So
Mm.
rather than this litigation was continued for so long, if the government had actually clarified on the policy, it would have been much better.
Correct.
Unfortunately, they did not, and here we are today. But what is also important is, and this is the reason, and because this issue actually came up, so a complaint was filed before the CCI, and I believe I've written
Mm.
about that also on the blog, so people can go and check that out.
Definitely.
Regarding predatory pricing by Jio, the accusation which Airtel made was that, look, you may think that Jio is not indulging in predatory pricing, but because how do you judge predatory pricing? You have to judge it by the books of accounts themselves, right? Cost and revenue, etc., profit, etc. But Geo is very smart in its accounting in the sense that the hardware, that is the infrastructure itself, is not in the name of the company. It's in the name of a trust
Oh
from
yes.
which the company has rights to use. So therefore, effectively, that cost is not coming to the books of the company itself. If that cost was to be
Wow.
taken into the books of the
Wow. Wow.
company,
Wow.
there's a
That
very
is very.
strong chance, and
Yeah.
obviously this is subject to it actually looking at those numbers because I also don't have access to those numbers, but there's a very significant chance the profit
Yeah.
of Geo would be far less, or there may not be any profit at all, for all we know.
Wow. Wow.
Yeah,
Yeah, but they give a lot of services for free. It's There might not be much profit from
correct.
it, right?
Yeah,
Correct. Because what we're just seeing is them just enabling everyone. Because one of the things, there is pre Geo era and there is post Geo
yeah,
era.
yeah, correct.
India became one of the biggest markets for all of these TikTok or anything.
Hmm.
If you look at it, because we all had access to these. Finally, we had unlimited internet access to
Hmm.
just watch whatever you want online, and we overtook QDPie in terms series took it
Hmm.
over. It's just a digital revolution that Geo brought into the country. It cannot be,
Yeah, so in all, you have to be fair to Geo. It brought in some very significant advantages. So you can't say that Geo has necessarily done everything bad or it's done everything illegal or
exactly,
wrong.
exactly.
There's significant advantages which have come in by way of this cheap service. But the question is at what cost?
Yeah,
And
true, true.
today, to have I mean, of course, 11 entities was perhaps too many for our telecom sector, but to now be down to virtually four and maybe two if things don't improve, that's dangerous, plain and simple.
That's dangerous. That's pretty freaking dangerous, man. Yeah, that's cool. So I think Azul rocks. You asked that question 4 to 5 times in the comments, and you were asking us again. So I think Sudipto aptly answered that. If not, check out his blog. He's written an article on one of those aspects. Moving on, I don't know the name of the person who asked this, but would you say that the scope of ACA, I don't know what that is broader than ADP for collective dominance action?
I'm not sure what ACA is
I,
exactly.
I, I even he wrote
Yeah,
an
could you please
abbreviation,
clarify
so
what
I
he's
don't know.
referring to? Yeah,
I
so
know.
if you're tuning in, if you could please just clarify what you're
Okay.
referring to in ACA.
So his question was, would you say the scope of ACA is broader than ADP? If you could just clarify that question, that'll be great. Let's move on to the next one. Janvi
Yeah.
Sharma has asked that the e-commerce bill has been pending for the last 2 years. Do you have any
Hmm.
comments on that? Do you think like
Nothing specific right now because it's changing a lot. I mean, that's the only reason I don't want to comment too much on it because there was a completely different regime which was initially proposed and it's all changed over time. Right? You initially, in fact, if you'll recall, anybody who wanted to engage in direct
Abhinav is here.
business.
Abhinav is here.
Oh,
Yeah,
okay, great.
his
I'll just come back
ACA
to
is
his question. Yeah, yeah,
that was fast.
yeah. He's online. That's a good sign. But
Yeah,
anyways, so just to answer Janvi's question first,
yeah.
if you recall initially when these e-commerce guidelines, rules, and FDI and all came into the picture, you had to have a 30% local sourcing component. Now you have an
Okay.
exception to that, which is why Apple is being able to come into the market. Initially, Apple wasn't coming into the market. They wanted an exception, which they eventually got.
Hmm.
So there's been a lot of back and forth, and the waters are actually flowing very fast in this area. So it's very hard to actually make any significant prediction. And now with these anti-competitive actions starting and all these vendors complaining, all these associations coming in, frankly, you just don't know where things are going to go. Right?
Correct.
But what I will say is that at least from a competition perspective, the CCI till now has been quite reluctant to actually begin action against these competition companies, because what happened was initially when these associations they filed the case before the CCI rejected the case, to which then therefore they went and appealed to NCLAT. Now NCLAT remanded back saying that no, there's a clear case, you start investigating. But in between that, they came out, the CCI came out actually with e-commerce guidelines saying make note of this when you're carrying out your operations. Now, what does that even mean in the first place? That's the first time ever you've actually seen guidelines from the CCI to companies and how they should be going about their business. So
Correct.
I'm personally not sure even what is going on within CCI when it comes to e-commerce right now, what they're thinking, what they're trying to do. But we'll have to see where things go, frankly.
Oh, all right. No, that goes on that.
Yeah.
Moving on to the next
Oh,
question.
let's just
So,
come back to his previous question.
Abhinav, yeah,
Could you
that's
just
actually
repeat that
Abhinav. I
question?
was
Yeah.
sorry, I forgot. So, I think he was referring to ACA as anti-competitive agreement and ADP is abuse of dominant position.
Yeah,
So, what
okay,
he's trying to
good.
say is, would you say the scope of ACA is broader than ADP for collective dominance action?
No, definitely
Okay,
not.
no,
Very
sorry.
limited, because at least in our Competition Act, Section 3 is limited to those cases, those
Mm-hmm.
specific circumstances. Whereas the moment, and collective dominance in general is much more broad, and not just collective dominance, but abuse of dominant position in general is much more broader than anti-competitive agreements. But specifically in regard to collective dominance, the moment if you insert those words which I referred in the 2012 amendment, jointly or singly, if you actually insert those words into section 4, you create this, you make the language of the section so broad that you actually allow collective dominance to be adjudicated. And since abuse of dominant position in general as a concept is so broad, it will allow many actions to come under section 4 which can't be brought under section 3.
Oh,
And that's
okay.
very common even now. In fact, it happens. Forget collective dominance. Even right now, most of our actions are often under when it comes to large entities under section 4, not under section 3. Section 3 deals with very specific agreements or the specific cases with relation to agreements.
Oh,
But
okay.
all your major cases are all under section 4, you'll notice.
That's very interesting. That's actually pretty interesting. Abhinav, we hope you've answered your questions. Now, moving on, there is another question I promise it's the last one. We have a few more. We are putting Sudipto's link with the lecture. Please go to him directly. You can definitely contact him because a lot of these questions are like a lot, and Sudipto's here for a limited time with us. So, But definitely, so Aniket Du has asked another question is that the
Yeah.
air tour case places a specific focus on implicit collusion. Can you elaborate on that?
Yeah. So I already did, but I'll just repeat it. When the merger happened, there in general, Air2s and the entity which it was supposed to merge with were extremely competitive entities within their market, along with other entities, with 3 4 other entities in the entire European Union. So in general, that market was quite competitive as it stood
Hmm.
at that point of time.
Yeah, correct.
But Air2s and the other entity which wanted to merge with it were the two most significant entities in the market. The others
Okay.
were much smaller compared to. So I believe it was two, one plus one plus four other entities, subject to correction. So
Hmm.
the other four were relatively small. Air twos and the other one were the two biggest.
Hmm.
So what the commission noted was that if theoretically this merger was supposed to happen, it would result in a situation where these two together would end up becoming a dominant entity. So
Okay.
once that would happen, then every other issue would come up. So
This is what
just to
we were
clarify
talking about
something here,
earlier. Yeah, that
yeah,
if
just to
two
clarify
entities,
something here because it's important to understand the slight difference between adjudication of which is where A2 is also noted that it can be structural or it can be contractual.
okay.
When you're assessing a merger uh, in collective dominance, then I won't say the criteria changes, but what happens is that it becomes um, how should I put it? It becomes different in the sense that you are theorizing what is possible. In a contractual case, you see what happens and therefore you accordingly take action. Whereas in a merger case, you are effectively theorizing what will be the consequences of the merger or the consequences of the two of them acting together.
Hmm.
So that is where one of, and because here is the, just to clarify, because I didn't talk a lot about this during my talk, merger regulation is now today under the 2004 merger regulations, ECMR. That's what they call. So European Commission merger regulations, 2004 ECMR, and the amendments which come in within that. One of the criteria is collective dominance. That is coordinated action between the entities, theoretical coordinated action between the entities if they were to work together. That is one of the criteria to determine whether a merger should be approved or not. So within that criteria, they actually examine theoretically what would happen if the two entities are working together. So
Yeah.
that is what happened in the Air2's case because the commission said that look, when the two of you act together, we are seeing a clear case of dominance arising as compared to the others in the market, and therefore we reject your merger. And that is in fact one of the main grounds why Air2's went in appeal. Because Air2's claim that look, the criteria which you use to determine a merger itself is wrong. That is not
Yeah.
the way you should be even determining whether a merger should happen in the first place or not. To which then the European court clarified that no, firstly, it can happen, and secondly, but there's a necessity to clarify how you're supposed to go about it, which is where the three-stage test came in. That it is one
Hmm.
thing where you want to use collective dominance or you want to theorize on coordinated action, but how do you actually go about theorizing it in the first place? Right?
Correct.
Because what had happened was, if you'll recall, the Italian glass case only left it at economic links. It never actually specified what the economic links were
Correct.
and
Correct. Yeah.
how you should in fact determine that an economic link has led to a common conduct between entities.
Yeah. This is a
So
very
that
dangerous.
clarification was
Yeah.
required.
It is a very dangerous, open-ended thing to leave the people with. That what is economy? We're not defining it. You just imagine it. Yeah, you're right. Yeah, definitely. So one of my personal questions was I'm going to get a question in. Just generally. So, how many would you say? How many people working together minimum would you say would be collective dominance? Can it just be two or like? See, there's a market. Let's just take there's a market. Like there's an e-commerce market. There are
Yeah.
5 to 10 players at max, right?
Hmm.
So, what would you say is collective dominance? Just two people working together, or is it like five, or like supposing seven of them are working together, right?
Hmm.
That definitely is collective dominance, right?
Hmm.
But what would you say is like, how do you define collective dominance personally, like particularly, and
Yeah.
in terms of you know, who is it? The market share? Is it how much money they're making? Is it how much of the market, not the market share they've captured, but is within that there's particular, that, they might be selling a
Yeah.
good which will be worth more than the other good that is being sold. We see that also.
Yeah. So I'll answer that question in two parts. First
Okay.
is, as a matter of principle, no matter how many entities there are, those entities together should be exercising dominance in the market, or should be able to exercise dominance in the market. That would lead to collective dominance. The
Okay.
second part of the question, and which still arises in our own jurisprudence even today, is how to determine dominance in the first place. One definite criteria obviously is if you control more than 50% share of the market. I mean, that's the most simplest criteria available.
Mm.
The second criteria, which is where the debate happens, is, let's say an entity does not control 50% of the market. Let's say it controls 40% of the market.
Yeah.
But the other companies or the other entities in the relevant market, let's say, all have just 5% each. So effectively, you see a situation where that even though that first entity, though it doesn't have a 50% market share, is clearly the dominant entity in the market, because the other ones are basically like ants before him or her.
Correct.
So
Correct.
that's I would say that determining whether there is collectiveness would be one part of it, and whether there's dominance would be a second part of it.
Okay.
Obviously, collective dominance would, and actually that is in one sense what Air2s did do, or attempt to do at least, because the three-stage test which it laid down encompassed within itself dominance. So if you have to actually adjudicate on collective dominance as a concept, and if you apply the three-stage test, the end conclusion, if let's say the investigation passes all three stages, would be that there is dominance in the market by these entities. So
Okay.
if you actually have to split the investigation, it would actually lead to more complications, because first, the fact is how to determine collectiveness and dominance as two separate entities in the first place, or two separate components in the first place.
Yeah.
Because as far as the second part is concerned, either an entity is dominant or not dominant. So it would end there, right? But then if collectively certain entities together could become dominant or not, will make the question far more complicated. So which is why Air2's evolved this three-stage test, where it effectively wanted to sort this issue out, saying that, look, you just apply this three-stage test. If this three-stage test is a check mark, yes, 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 and all three, then there is definitely collective dominance happening. But I do understand that I might have not been completely clear in my answer right now, because obviously it's a complicated subject, because
Yeah. It's very
investigation is a
something.
whole different ball game, and investigations
Yeah.
in general in competition law are extremely complicated because they're
Correct.
factual, right?
I definitely agree with that. Definitely agree with that. Thanks, Sudipto. Thank you for your time. Thank
Thank
you.
you for having me here. It's always a pleasure, and
Please,
I
it's always
definitely
a
enjoyed
pleasure.
this session today.
Yeah, even I did, man. It was so interesting, so informative, and we look forward to having a hat trick with you. Another one
Oh
very
wow,
soon.
thank you. Yeah,
So
more than happy
definitely,
to.
everyone, this is Sudipto Sarkar, advocate in the Supreme Court, practicing, and he has his own blog called the Indian Competition and Antitrust blog. Please
Correct.
do. He regularly writes there. He's been writing there for a long time. Uh, Thank you, Sudipto. And we have another question.
Yeah, why not? You take a call if you want to, because obviously
Okay,
it's
okay. Just let me just ask a question. Would the market structure be any kind of a factor to determine collective dominance? I think you've already answered this though, in
yeah, I
terms
sort
of
of did. It will obviously it's one of the factors. When I was answering you only, I ended up answering it. So yes, but it's a very fact specific question. Oh, that happens in all competition law cases. They become very fact specific once the investigation starts, because you have to look at the individual dynamics of the market itself.
definitely, definitely. Anugrat Dua,
Exactly
I'm going to
one
put.
example of that, I just conclude on this, would be actually our mandis. So if you, I mean, anybody's actually been to a mandi or has to
Correct.
interact with the middlemen there.
The sellers,
Sorry?
the bandi, the
Yeah,
vegetable
yeah.
sellers.
You'll realize, and this the CCI realizes the hard way, because there was this onion cartel investigation which started initially in the CCI. This is a long time ago. I believe when we were
Yeah,
in
yeah,
college, that is when it first started, or just when we
yeah.
came out of college. They quietly closed the investigation. because they realized if you really wanted to conduct an investigation, you would actually have to go down to the mandi and interact with the middlemen, because otherwise you would not be able to. And unfortunately
Yeah,
for them, the middlemen knew how to deal with these things at the ground level.
exactly,
So you
exactly.
have to actually थोड़ा बोलते हैं ना हाथ गंदा करना पड़ता है कुछ
Yeah.
investigation में, right? But
So,
it's actually, in my personal view, a very good example of collective dominance, because mandi rates within the mandi are almost virtually the same. You'll see
yeah,
very, very little difference between mandi rates
correct,
within the mandi rates.
correct.
But I don't know
So,
if they
yeah.
actually have the guts to ever conduct that investigation.
So there are two economies. I always say that there's one economy you
Always.
know, and
Yeah.
second economy works, and there's no law there. So
Yeah.
yeah. So
It
yeah,
has its own
definitely.
law.
Thank
It has
you.
its own rules.
Yeah, it is own law. It has its own people who work there. So yeah,
Yeah.
Sudipto, thank you for coming. Great. We'll definitely. The people are going to call you again. We'll put his link in the bio. Please stop for everyone who's asked questions. You can definitely contact Sudipto Sircar directly. And before you do, definitely he has his blog, Indian Competition Antitrust blog, which he has been writing for a number of years. So you will find your answers over there. And so, thanks, man. Thanks for being here. Thanks for taking out the time for
Yeah.
us.
Thank you for having me. Thanks, Govind.
Right.
See you.
Bye.
Bye.
See ya.